Good afternoon, Zach Lucas, McCarthy Denning. Just bringing us in on this webinar on the Philippines and Japan as part of the regional talks on the governance and succession series. Just talk through the series. Obviously, this is now the second of the regional talks. We've got one more, which is Malaysia and Thailand. That'll be a week, 2 weeks from now, actually. So we're going to have the next week off. And then on the 24th of September, we're going to wind up the entire series with the single family office. And it will start to be publicized, but the program for this will involve an analysis of the VCC legislation and the use of VCCs as family offices as compared to a ordinary Singapore PTE. So the idea behind it is to do a comparison from a governance perspective, and we'll also look at structuring a multi-family office using a VCC and look at if the families wish to have a trust structure above, what would be the correct approach? Would it be a multi-fund trust, or would it be separate trusts under a private trust company? And we'll look at some of the practical ramifications of holding a VCC through a trust. As I say, we'll do the comparison so that the governance is teased out, and then we'll end up with some analysis on the trust side. And we'll also obviously invite Spencer Su from the Monetary Authority of Singapore to discuss broadly about the VCCs, future plans for the VCC and how it's getting on in terms of its take-up, and to talk some about the grants that have been made to help with the adoption of the VCC as a planning tool. So you will see on the chat, I've placed a link to the Malaysia-Thailand talk, which is on the 23rd of September. So if you haven't already registered, then by all means, go through that link, and that will take you to the registration page. You can get going with that. Okay, now going back to today's session. So today we're dealing with Philippines and Japan. In terms of the panelists, as usual, I'm very grateful to be joined by Spencer Su from the Monetary Authority of Singapore. I'll also be joined by Joshua Pariso from PJS Law, as well as Tsuchi Yoashi from Mori Hamada and Matsumoto in Tokyo, Japan. And so these are all our panelists today dealing with the various issues. So from the agenda standpoint, we're going to run through the demographics of the various sort of business families in each of the regions, look at the succession planning tools that are principally adopted. We'll look at the governance planning tools that are principally adopted in the jurisdictions. And then we'll look at an interesting area for these jurisdictions, which is the ability for international structures to be used as part of the planning process. And this will be an interesting discussion because there are some sort of scope to have an involvement from jurisdictions or international financial centers such as Singapore and obviously Hong Kong. Then we'll look at the demand for domestic family offices and run through how that's looking in each of the jurisdictions as we sit. And then finally, we'll wind up with the demand for international family offices. And here we will concentrate specifically on the Singapore single family office and look at whether or not the families in each of Philippines and Japan may utilize a Singapore single family office for their international structuring and planning. So just looking at the demographics, what I'll do is I'll ask sort of Joshua and Sushi to help us to go through this. The questions are really, as we've done in the previous series, which generation is typically in control of the business families in each of their jurisdictions, the average number of family members that will succeed to the business, because this gives us an idea of the level of complexity that the family will face. And then how soon is this likely to occur? So how urgent is this in each of the different markets? So I'll ask Joshua to kick us off. And so Joshua, in terms of the generation that's typically in control now, are we looking at still first generation businesses, or are we looking at third generation? Where are we in terms of the Philippines as a generalization?
Sure, Zach. Just a bit of a background on the Philippines family business profiles. In the Philippines, 80% of the businesses are family owned or controlled. I think in one of the research done by Credit Suisse, the Philippines ranked 11 globally in terms of family-run firms. So right now, at least two of the large family enterprise in the Philippines are now on their sixth or even later generation. However, majority of the family businesses now in the Philippines are still being currently controlled by the second generation. Yeah.
Right, right. And what will succeed then? What's the number of family members that we anticipate that will succeed in the cousin generation? How many do we think on average will succeed?
Okay, so since we are looking at the second generation as currently the majority in running the family business, the successors being the third generation, the siblings on the second generation level are usually around 5 to 7. So with the third generation getting involved, who would be now the cousins, the first cousins, they would number around 15 to 21 in the average because each sibling would approximately have an average number of children of 3. So we're looking at the 15 to 21 family members in the average.
Right. And do you think that, one of the biggest issues that we've encountered with many of the family businesses handing off is the next generation is simply not interested in joining the business. They don't want to do it. They want to do something else. Do you see that happening in the Philippines?
Oh yes, I have seen that in some of my clients. Some of the children, or even majority of the children, not being interested in joining the business and doing something else. At most, in some of my other clients, there would be at least one child who would be involved in the business, but there would even be times that that child would even be sort of forced into getting involved in the business.
Right, right. And how urgent is all of this in terms of timing? The second gen, are they in their 70s or 80s, or where are they in terms of the succession here?
Sure. The second generation profile in the Philippines is typically they are in the 50s to 60s age bracket. Right. So looking at that statistics, succession by the third generation should be anticipated within the next 10 years.
Right, right. So it's not a burning, urgent issue for the family at the moment, but it's something that's obviously on the horizon.
That's right.
Right, okay. And Sushi, from your perspective, how does it look in Japan in terms of the generation in charge? Where are we?
Yes, actually, the situation in Japan is very similar to that in Philippines. So actually, most of my clients are second generation, and they are thinking, their concern is how to ask, their parents to retire from the business. Right. And yeah, that is the biggest issue for the second generations. And also number of the, family members, decreasing because, the population in Japan is starting to decrease. So right. Number of children are also decreasing. So in many cases, just 1 or 2 or 3 children are discussing, about the success.
Right, and in terms of how interested the children are in joining the business, do you see also the similar drop-off with a lot of the children absolutely having no interest in the family business?
Right, I see that cases actually, and yes, many people are not starting to lose the interest in the business, so they are doing totally different work. But in Japan, in many cases, they will come back to the family business maybe 10 or 20 years later. That's always very often happen, very often, because even if they start to another business, they usually go back to the original family business. That is very common.
Right. And in terms of the urgency of helping families with the transition, obviously in the Philippines, the magnitude of the people involved will increase the complexity. In Japan, probably the changing of the guard is probably going to be the same amount of people involved. But when are we anticipating that from a Japanese perspective? Is this within the next 10 years that we expect that?
Right. So in Japan, there are two ways for the succession. One is inheritance, and another way is basically gift or sale of the shares. But in Japan, from based on tax reasons, inheritance is more preferred. So that's why we have to usually wait for 10 years or 20 years for the succession.
Right. Okay. Looking at the actual succession plan, and the questions I'll ask is, do families typically trade in corporate partnership or other forms? So what platform do they tend to use in terms of the legal arrangement? Do families typically transfer the business on death or during lifetime? And there's obviously some tax issue there from a Japanese standpoint. Do families typically structure succession via use of a trust or other arrangement? Both Japan and Philippines has domestic trust laws, so this is open to the families. Do families transfer the business to the next generation in equal shares, or do they prefer the oldest son? Do they exclude daughters? How is it typically done within the family? And then finally, are there any community of property or forced heirship clawback claims that could disrupt a transition of the business such that it could include people that perhaps were not intended and probably won't add much value to the business? So fair list there. So Josh, if you can sort of work your way through that in a sort of casual way. Do they typically trade in corporate form or partnership in Philippines?
Sure. In the Philippines, the more popular or preferred vehicle is still the corporate form, I should say. Corporate vehicles are often used by the larger businesses and even the medium-sized businesses. But that is not to say that there are other businesses, more particularly the smaller businesses would still be in the form of partnership or even sole proprietorships, probably because of the size of the business. But as I said, the more popular vehicle is still the corporate vehicle.
Right.
Yeah. So in terms of transferring the business to the second generation, typically majority of the businesses here still transfer the business on death.
Really?
My observation is that the first generation or the patriarchs or the matriarchs, they usually are involved in the business up to the last breath. So
Really?
they would usually be involved. But for the larger businesses, they would normally already involve the second generation slowly into the businesses. But I would say for the smaller businesses, this is not the scenario. So transfer of businesses would usually still happen upon death of the patriarch or the matriarch.
Right. So no real room for complicated structuring and putting it into trusts and doing things like that. It's basically going to go through a testamentary route.
Yes, that's still the usual route, testamentary route, or even worse for those who have not been able to prepare their last will and testament.
Right.
The law kicks in terms of inheritance law. Yeah.
Right. And in terms of the community property forced heir, probably these things haven't even been considered then.
That's correct. In the Philippines, the default property regime is what we call absolute community of property. So that means that when you have a couple, spouses, husband and wife, when you say that they are under the absolute community of property, everything that they put into the marriage at the time of the marriage are divided equally. They are shared equally. Right. So without any structuring or without any prenuptial agreements in place, that is usually a complication when one of the spouses die, because automatically the other spouse would have 50% of the estate immediately upon death. So that is by operation of law, 50% is already for the other spouse.
Right. And if they do plan on the succession, do they generally favor the male sort of eldest heir, or how do they generally, or is it equal across all of the family members regardless of gender?
Okay. Uh, Typical of the Filipino businessman here, especially the larger businesses, would be Filipino Chinese
Yes.
tycoons. So as we all know, in Chinese culture, uh, the uh, the male child, especially if you are the eldest child who is a male child, is still preferred
Right.
to run the business. So we still see tinges of those in the businesses here in the Philippines. They would prefer the male over the female children.
Right, right, okay. And Tsushi, from your perspective, how does this sort of list of queries on the succession planning, how does it look from a Japanese standpoint?
Yes, in Japan, it's very similar. Japanese people generally prefer corporate, form, because I think the biggest reason is tax, because corporation tax rate is around 30%. But if we use a partnership, the partnership is transparent for Japanese tax purposes.
Right.
And if individual is a partnership members, they are subject to individual income tax, and the applicable tax rate is up to 55%.
Right.
So I think that's the biggest reason for Japanese people to prefer corporate form.
Right.
And yeah, in Japan, they usually transfer the business on death rather than during the lifetime, because if we transfer the business on death, inheritance tax will be imposed, and if we transfer the business during lifetime, it's subject to the gift tax. But in Japan, the tax rate for inheritance and gift is almost the same.
Right.
So to defer the timing of the taxation, transfer the business on death is more preferred in Japan.
Right.
And yeah, so in Japan, trust traditionally the trust was not so commonly used, but recently many professionals, including me, recommending the clients to use a trust.
Right.
So in in terms of the succession planning, the trust is more and more popular recently. Actually, it's very useful from legal and tax perspectives in Japan.
Right. And the community and sort of clawback, how do you deal with that in Japanese context?
Yeah, so it's we have a very strict rules about the community property and forced their clawback in Japan. So in this context, the trust is very useful in Japan, because if we use a trust, we can separate, controlling rights from economic rights.
Right.
And so if we give the economic right to the spouses or other family members, their rights under the community property or, clawback, force their clawback are satisfied. But voting right or controlling rights can be held by only one person, even after divorce or inheritance. So trust is very useful in that perspective.
Right. And Joshua, you have trust laws in the Philippines. Do families not utilize the trust laws for these purposes, for these business successions, in the same way as we're seeing emerging in Japan?
Okay. We do have trust laws, but not very specific. We more or less just follow the trust provisions under our civil code. But my observation is that while trust arrangements are not very common in family businesses, the larger businesses actually already use this vehicle. I've seen clients use the irrevocable trust vehicle as way of structuring the succession planning. In that way, the assets are taken out of the estate already of the person or the patriarch, and they immediately they are considered or treated as gifts at the time of putting the assets into the trust. And so this is just subject to a gift tax. And recently, because of the amendment of the tax law in the Philippines, inheritance law and gift or donation taxes and inheritance taxes are almost the same, or they are at the same rate already. So there is no incentive now to prefer the other one. So with that, if the trust vehicle gives more flexibility in terms of managing the assets, then the larger businesses prefer that as a vehicle.
Okay. From the governance planning perspective, now this area is really principally dealing with how families create frameworks so that the next generation can actually work together in a better way, so that they avoid, the pitfalls of people misunderstanding, people who want to control, not being in positions of control, people taking money out of the business when they shouldn't be. So this is all about, governance is really about preparing the next gen to work together successfully, right? So do families create specific governance frameworks to help them to achieve this? Do families take into account the best practice corporate governance codes that are mostly promulgated through the listing rules in all of the jurisdictions that have significant stock exchanges? So some of the rules that we would typically see in good corporate governance would be things like the need for independent directors, separation of chairman and CEO roles, so you don't have, you don't have a unified position, that there's no accountability between the two. Enhanced transparency and disclosure of information across the business to the shareholders or up into the trust and the beneficiaries if you have one. Enhanced related party transaction rules so that family members actually understand what conflict of interest means. Many times we take it for granted as lawyers, but for a layperson, these are obscure terms. Director remuneration related disclosure rules. How do we control family members extracting profits from the business through salary effectively? Independent auditors. So how do we make sure that there's financial hygiene across the business? These are just some of the rules that you'll see typically on these sort of best corporate governance rules that are on the listing requirements. Enhanced minority shareholder protections. And then if we do have corporate governance rules in a jurisdiction, or we do see that families are adopting this approach to prepare the next generation, where do they put these rules? Do they have them in a shareholder agreement? Is it in the constitution, or do they try and embed them into these trusts that are starting to be used? So I think, Tsushi, if you can help us with this first, in terms of corporate governance frameworks, are families starting to adopt this? Do they understand the need for the next generation to have something that they can use to help them to be successful?
Yeah, actually in Japan, the traditionally, Japanese family governance framework only focus on the family matter only. That's a tradition, but recently there is some other new trends in the case of the listed companies. So if the family is a majority shareholder of the listed corporation, some family governance framework thinking of not only family matters but also minority shareholders. So I think the purpose of the corporate governance code is to protect the interest of the minority shareholders. So some new family governance framework starting to incorporate the concept of the corporate governance code, including independent directors or enforced related party transaction rules. So those some parts of the or some concepts of the corporate governance code are starting to be incorporated in family governance framework. So that is a Japanese trend, I guess.
Yes. And where do they typically put them? Is it in the constitutional documents or the memorandum and articles of the company, or is it in the shareholder agreements, or where do they generally end up, these corporate governance rules?
the shareholders agreement is common because in corporate constitutions or articles of incorporation is always simple. That is Japanese style.
Right.
So many details, terms and conditions are provided in the shareholders agreement. But recently, as I said, the trust is more preferred than the shareholder agreement because if we think that 100-year planning, trust is more stable from the legal perspective. So
yes.
trust is more and more preferred recently.
Right. Okay, Josh, from your perspective, how are families taking these sorts of things seriously for next gen planning? Are they actually starting to look carefully at how the next generation can work together?
Yes, I would say that governance frameworks are pretty much popular on the top family businesses, meaning the bigger businesses.
Right.
Probably because coincidentally, these large family businesses here in the Philippines would usually be listed companies in the stock exchange. So being listed companies, they are really governed by stringent rules. We have our securities regulation code, which often than not would require all of these best practice corporate governance codes. So they tend to already incorporate these governance frameworks in the business. However, in the smaller businesses or even the medium-sized businesses, there's still no, usually the situation is there are no governance frameworks in place, or if ever there are governance frameworks that are in place, I would say these are poor governance practices. So, so that's the difference basically between the larger businesses, the listed companies, and the smaller businesses. So, in terms of the vehicle for those with those businesses that have governance frameworks, the shareholder agreement is the more popular vehicle. Corporate constitutions are usually seen in large businesses or large family businesses or extended family businesses. So I've seen some of those, at least in my clients. I think I have 2 or 3 who would have family constitution, but these are more the bigger businesses.
Right. Because that's what I was going to get onto, which is obviously family constitutions are becoming incredibly popular, particularly across Southeast Asia as families look through. In terms of the questions that I have on constitutions, it's really getting a feel from a sort of Philippine standpoint and Japanese standpoint, how much of these things being adopted or looked at by families, how popular are constitutions? What are the legal implications of a constitution? And then finally, who typically is preparing this? What we can generally see in the marketplace is if practitioners, lawyers, let's say, or professional accountants are not talking about these particular frameworks with families, then it tends to sort of default to business schools filling the void. And you have academic business school approaches to how families should create their constitutional framework. So just wanted to get a feel, how popular are these things? What are the ramifications of adopting a constitution? And particularly, who are drafting these documents in your market? Is it lawyers, notaries, or is it a sort of business school academic? So I think, Joshua, if you can kick us off on this one.
Sure. As I've previously mentioned, some of the bigger businesses here in the Philippines have already adopted family constitutions or family charters. And I've seen 2 or 3 of my clients having family constitutions. So I think it's getting ground here in the Philippines. And I'd say that probably in the next few years, more and more businesses would probably employ family constitutions in their businesses. In terms of legal implications, family constitutions are usually just a 2-pager or 3-page document that usually governs how succession is done in a family-run business or how income is divided. So in terms of legal implication, I would say that in the Philippine setting, a family constitution would be in the nature of a contract between the family members,
Right.
especially if this document would be a signed document by the family members or all of the stakeholders. You can treat it as a contract. And being a contract, then its provisions are enforceable in a court of law.
Right.
Because it's governed by contract law. So any breach of the provision can be a cause of action by any of the family members. In terms of preparation of these family constitutions, I'd say that the first initiative would usually come from the family members first. They would express their preference on what provisions would be in place in these family constitutions. And the advice of the lawyers would come next. So they'd vet these family constitutions, whether they would be in accordance with law or public policy. So, but I've seen family constitutions that have been prepared without advice of lawyers. So in those kinds of instances, when trouble or conflict arise and they invoke the family constitutions, as I said, you can treat that as a contract. And if there are problematic provisions in the family constitution, then we have a rule in Philippine contract law that the law is deemed written into every contract. So if the provision therein violates any provision of law or public policy, then that gets to be voided. But the rest of the provisions that would not be problematic would still be in place.
You see, the popular perception of family charters is that they're not legally binding and they don't have contractual force. A good family constitution would where it's being drafted correctly, will say the family should agree by way of a shareholder agreement the following provisions, or the family should amend their constitutional documents on the company to reflect what's being agreed. A poorly drafted version of a constitution won't say any of that. It will just ramble on, talking through the issues. And in the Philippine context, it's tantamount to creating a contractual obligation between the shareholders.
Yes.
In effect, right?
Yes.
So in that case, how likely is it that families will inadvertently get involved in constitutions that actually have legal force and have no clue that they're actually creating legally binding obligations?
Well, that can really happen. I would say in the smaller businesses, because they would usually, the normal course of things in smaller businesses is the matriarch or the patriarch dictates. Whatever they say is law of the family business. So they usually wouldn't mind getting advice from lawyers or financial advisors as to how sound the provisions of the family constitution is. So the probability of complications down the road is really high.
Right, okay. And Sushi, from your side, how do you see the use of, or the development of the use of charters in a Japanese context? Are these things popular?
Sure, yeah, it's very popular. Traditionally, many Japanese families have, kind of family charters, but it's very simple and it's just a one-page document, and usually it provides only maybe 5 or 6 articles, and it's not legally binding, and nobody signs on that document. So that is a traditional way in Japan. But recently, some big families are starting to enter into some agreements or contracts among the family members. That is a new trend, and we call it kind of a family governance agreement or family governance contract. And basically that agreement is legally binding, and of course basically all family members will sign that agreement. That is a new trend in Japan. And in terms of the parties to prepare those documents, in many cases, such new agreement type of family charters are prepared by lawyers. And also many lawyers are working with business school academics and also outside consultants.
Yeah.
So basically, we are working together, those, professionals to prepare the, new type of, family charters.
Right. So how do we get a new family member? Let's say we have a share transfer on one of the shareholders' death, and we have a new shareholder being introduced through the estate. How do we get them to agree to this family charter? If they say, I'm not interested in this, I had no part in making it up, it doesn't reflect my values, and I'm not prepared to sign this, does that mean that we never register them as a shareholder? Or how is this done?
Yeah, that problem is very common in Japan
Right.
if we use a shareholders agreement. But if we use a trust agreement, that problem can be avoided
Right.
because beneficial rights is automatically transferred
Exactly.
to the, or sons or daughters.
Right.
So from that perspective, trust arrangement or trust agreement is very useful in Japan, and it's more and more, preferred.
Right, right. And Joshua, from your perspective, how do they enforce it against new shareholders? Sorry, Josh, you got your mute?
Sorry about that. In terms of enforceability of these family constitutions to new shareholders, actually, it is something that is yet to be tested in Philippine jurisprudence.
Right.
So I don't think there has been a case which has been ruled by the courts on this issue.
Right.
But I would say that because a new shareholder was technically not part of that family constitution, then it's arguable that they can actually not follow the provisions of that family constitution, and by virtue of inheritance law, if that particular new shareholder just really inherits the shares of the father or the mother, then he gets the shares in the company by operation of law. And I think that cannot be that the family constitution cannot override the provision of law that provides that he would own the share by succession rights. Yes.
Right. Got it. Okay. Very good. Looking at the international side now, really the interest here is it possible to structure succession to a domestic family business using an offshore entity or arrangement, offshore trust, offshore companies? And if it's possible, what are the main considerations? So, Atsushi, from your perspective, is it possible for a Singapore trust to be used in a domestic Japanese context to assist in the succession planning to a Japanese business? Is that possible?
Right. Of course, it's possible. And, in the past, many Japanese, wealthy individuals prefer using the corporations rather than the trusts. So they usually set up, foreign corporations in the past. But, Japan has a CFC rules, which is an anti-tax haven tax regime. So if under that tax regime, if we use, foreign corporations, the shareholders in Japan are subject to the Japanese income tax.
Right.
So it's very problematic for the Japanese taxpayers. So that's why many Japanese, taxpayers or Japanese wealthy individuals prefer using the trust, offshore trust, because trust is basically, transparent for Japanese tax purposes, and we can avoid the issue of the Japanese CFC rules. So by avoiding those tax issues, Japanese wealthy individuals can benefit from Singapore trust.
Right, right. And Joshua, from your side, is it a similar story from a Philippine perspective in using a Singapore trust to help to structure a domestic family business? Is it possible?
Yes, I think it's legally possible to structure it this way. Some businesses here, more especially the larger businesses, have already BVI companies or Hong Kong companies that are in place as part of the tax management of their businesses. So I would say that they would be open to considering offshore arrangements for the business succession. But similar to Japan, the main consideration is tax. Tax, of course, is the main consideration. Under Philippine taxation law, Filipinos are taxed from all income within and outside of the Philippines. So we would like, probably Filipino businessmen would like to see whether these offshore entities or offshore arrangement would be tax efficient in such a way that they can be used as some sort of tax haven. And probably if it's seen that way, then it will be an attractive vehicle for them.
But from a Philippine standpoint, you don't currently have CFC rules, is that correct?
No, we don't have
and
CFC
is there
rules.
any suggestion that you will implement CFC rules as part of this BEPS rollout of jurisdictions trying to equalize? Is there any suggestion of that?
In the immediate horizon, I don't think there are considerations for that. Yes.
Right. So in both cases, you can look at structuring businesses. Not only, obviously, if the businesses are internationally spread, then it's easier, obviously, to structure through an offshore trust, whether it's based in Singapore or elsewhere. You just have to be careful from the Japanese standpoint that you structure it correctly for the tax to not bite on the CFC, and from a Philippine perspective, are you careful about round tripping and having sort of how assets will be dealt with coming back in from the international structure? Is that one of your considerations?
That's also a consideration, because any income, even if it's income coming from a different jurisdiction, is still taxable because of your citizenship. So whatever income you derive from whatever source from anywhere in the world would be in the radar of tax authorities.
Right. And just final question on this, from a Japanese standpoint, do you have any foreign ownership restrictions when it comes to domestic companies? So foreigners can't own more than 50% of a domestic company, or can foreigners own 100% of a domestic company?
Yeah, in Japan, it is possible for the foreign investors or foreign shareholders to have the 100% in the Japanese corporation. It's possible. But recently, Japanese Foreign Exchange Act was amended, and inbound investment a little bit, restricted under the new Foreign Exchange Act. So, there is a trade war between China and the US now, and the Japanese government has a similar concern, and they recently amended Exchange Act, Foreign Exchange Act, to that effect.
Right. And Joshua, from your perspective, any sort of foreign ownership controls in the Philippines so that you would restrict the amount a foreigner could own on a domestic Philippine company?
Okay, as a general rule, a foreign company can own shares in a domestic company 100%, except that for those industries that have been specified to be nationalized. So we would have graduation of business or industries that are required to have 100% Filipino ownership.
Right.
There are businesses that would require, that would allow foreign ownership up to 40%.
Right.
60% Filipinos. But in terms of, if you're just looking at a holding company, I don't see much restrictions on foreign ownership in terms of a holding company.
Right. Okay, so turning our attention to the family office, the sort of advent and growth of family offices. As we all know, as families become a lot more sort of wealthy, there comes a point in time when they start to develop a balanced approach from the business, and now they start looking at non-business wealth. And sometimes the non-business wealth is embedded into the business and managed out of the business. But generally there's a sort of maturation here where they generally separate the two going forward. So from a domestic standpoint, is there demand for family offices currently? Is it growing? And which is more prevalent in the marketplace? And I make the distinction between a multifamily office an investment office, and a single family office. A multi-family office is a commercial undertaking where effectively it's an external asset manager that's professionally managing family wealth. So it's not a collection in this instance of families coming together and pooling their resources into one family office. This is a professionalized approach to managing the financial assets of various clients. An investment office is put in there because it's really, the profile doesn't fit a family office in the context that it's not collective family wealth. It's usually an entrepreneur or a relatively young individual who's managing their wealth, and they're doing it in a professionalized approach and not taking the advantage of, let's say, the various private banks that are available. In this context, a single family office is what we would say a bona fide family office. So this is collective family wealth being centrally managed, maybe with many branches of the family being involved. And that's the distinction. So in terms of looking at it from the, say, Philippine standpoint, which is more prevalent right now? What do we see growing? Is it multi-family offices, investment offices, or bona fide single family offices?
Okay. In the Philippine setting, I would say that multiple family offices and investment offices are the more popular ones. We do not see a lot of single family office setup. I think I've searched and the horizon, and I think I was only able to see probably 2 or 3 single family office attempts at structuring family businesses. So it's really more of the multi-family office and investment offices. And I also observed that some of the accounting firms, the bigger accounting firms, would offer these services in terms of advising on multi-family office and investment. So because it makes sense for the businesses, because normally they would have independent auditors already engaged by them to perform the independent audits, and they would already be familiar with the financials of the businesses. So it makes sense to give advice further on investments.
Right, right. Katsushi, from your side, what do we see going on in Tokyo?
Right. So actually, in Japan, the concept of the family office is very new. So to Japanese people. So traditionally, Japanese families, just select only one employee, and ask him or her to support the family. So, but it's just one employee of the company. So, but recently, some bigger, families are starting to set up, their family offices, and they employ the outside professionals, and those outside, professionals are working for the family. That is sometimes called, family office, but still, the concept is very new.
Right.
And so that's why maybe we don't see multi-family offices in Japan, and we sometimes see single family office, but it's not so common at this moment.
Right.
And another problem is, these family offices are subject to Japanese financial regulations, because they have some discretion to invest in the financial portfolio on behalf of the family. So that action is subject to the Japanese regulations.
Right.
So that may be another reason that, these type of family offices are not so common in Japan.
Right, right. Okay, well, that's helpful. I think from this is transitioning to the international family office, and what I'll do is we'll enter into a discussion around the sort of demand for international family offices from the high net worth families in each of your jurisdictions. But what I will do is invite Spencer to take us through one of the more prominent jurisdictions in sort of up and coming in terms of the family office space, which is the Singapore single family office, and it's sort of stratospheric growth over the last few years in terms of use. And I'd invite Spencer to talk through some of the aspects on the single family office in Singapore, and then we can talk generally about the demand for international family offices from each of your regions. So Spencer, if I'd invite you to make some remarks on this.
Right, thanks very much, Zach, and also to Joshua and Atsushi for the very useful sharing early on. I think through the discussion, I've had a better understanding of the family governance as well as corporate governance and family office landscape in each of your locations. And indeed, like you guys have mentioned, the concept of family office is something that is very new in Asia, and we are just starting to see family offices becoming an important concept of wealth planning and succession planning amongst the business families. Over here in Singapore, I think there has been a very strong interest in this area as well, and we have seen interest coming from families from around the whole APAC region, as well as a selected number of family offices from the US and the UK. And based on the feedback from many of these family offices, they like the strong rule of law, the financial economic stability that Singapore provides. And on top of that, it's also the high quality of living, high standards of living, because families typically want to be co-located with their family offices. And hence, I think as a result of these factors, we have seen the number of family offices grow by about 5 times between the 2017 to 2019, amongst which I think we have seen a few Japanese family offices that have established here. And I think in terms of Filipino families, probably 1 or 2. Yeah, and I think that's kind of reflective of the situation in each of your locations. And I think one point that that comes across for me is that international family offices tend to be useful for families which tend to have become more international in nature, be it in terms of the nature of their business. It has expanded beyond their existing borders, or maybe the family members are located in different parts of the world. They could be, the family is based in Asia, but the children study in the UK and they have investments in the US. So for such families, it makes sense for them to have an international family office. And I think earlier on, it was also highlighted that, areas such as tax efficiency would be an important area of consideration, as well as also the ability to, move your assets under within the trust structure. That's also where Singapore has some form of attractiveness to family offices, given that on our end we do offer tax exemption incentives for families that set up their family offices here. So this would be more popularly known as the 13X and the 13R schemes. Essentially, it allows the family office's investment to be tax exempted for as long as the management of these assets are being conducted out of Singapore. So essentially, the family has to just set up a family office in Singapore to manage these assets. And then if they meet the criteria of the award, then they can avail themselves of this tax exemption. And the criteria of the awards would be some elements such as total expenditure. You're expected to spend about 200,000 Sing dollars as on an annual basis. And also there are some professional headcount requirements, having, for example, 3 investment professionals for the 13X incentive, and also a minimum asset under management, which is currently set at about 50 million Sing dollars to qualify for the 13X. So that's one aspect which is attractive to family offices. And also the other aspect is, if you look at the context of a trust, so taking into consideration the CFC laws in Japan, then a trust structure would be a viable structure for holding the assets of a family that wants to set up an international family office, so that it doesn't get implicated in the CFC regulations. And then the trust can be structured in such a way that the assets can still be managed by the family office, or if that there is interest over there, the families can also choose for these assets to be managed by professional managers. I think I'll just pause here to see if there's any questions or views from our panel here, or maybe from some of the other viewers of today's webinar.
I thought one aspect I thought we could talk about was, that Spencer just mentioned that that having a trust structure was more efficient from a Japanese standpoint. And I would just ask, in terms of 13X, if we just had a trust with effectively a fund management company providing services to the trust, would that be something that would be entertained for a 13X application? Is that possible?
Yeah, so this is 13X. Essentially, I think what it requires is that I think this is useful to share more about the difference between the 13R and the 13X. So in the context of a 13R, the entity that's holding on to the investment assets needs to be a company which is registered in Singapore. Whereas for the 13X, there is no restriction on the type of legal entity that can be used to hold these assets, which means that the trust structure can be used to hold the assets that belongs to the family. And then in terms of the manager, because you don't want to have a so-called a company which is established, which could attract implications on the CFC front, then they could appoint a professional manager. This could be either, for example, a fund manager, or even a private bank could be the appointed manager for this trust structure. And then in that sense, they will be able to benefit from the 13X incentive and without having to set up a company.
Right. And then, Susha, do you see a growing demand for international family offices from a Japanese standpoint? So do you think that these things are going to be helpful going forward in terms of the facility that's being allowed?
That's right. So I think this international family office structure will be very useful or helpful for Japanese families, because I think this international family office is not subject to the Japanese regulations, so it only subject to the Singapore regulations. So that may be very helpful for Japanese investors. And as you discussed, the point is we should not use a corporation in the international family office structure from a Japanese tax point of view, because as I said, if we use a company or a corporation, that is subject to Japanese CFC rules. Right. So we can only use the trust only. So that's why I think if we choose the 13X structure, so that should work for Japanese families.
And what's the attributes of the trust? What does it need to have? Is it fully discretionary in terms of the beneficiaries, or does the trust have to create income interests, what we would call a life interest? Or what's the attributes of the trust?
So I think in terms of the structure of the trust, there is quite a good amount of flexibility in terms of being able to qualify for the award under a 13X structure. I think firstly, the trust should be holding assets in excess of 15 million Singapore dollars. And then on the investment professional front, if it's managed by a single family office, you need to have 3 investment professionals. If it is managed by a professional manager, then the same rule applies. But I think in the context of a professional manager, they tend to have usually more than 3 investment professionals. So they would be able to meet the requirement. So then it boils down to the annual expenditure requirement, which is 200,000 Singapore dollars. So that could be in terms of fees being paid to the professional fund manager. or any related corporate secretariat services which are being rendered. Or yeah, I think even in terms of, let's say in the context of the trust, this could be paid to the trustee as well in terms of trust administration fees.
Right, right. And that's actually, in terms of the beneficial interests under the trust, does it need to be a particular form of trust? Does it have to be revocable? Does the grantor or the settlor have to retain an income interest? Is there any qualification here?
Right. So in Japan, we have two types of trust. One trust is transparent trust, and the other one is corporation type trust. So if it's categorized as a corporation type trust, again we have to think about the Japanese CFC rules.
Right.
So we make sure that the trust is treated as transparent for Japanese tax purposes. That is the most critical and important point. And to make it transparent, we have to identify who the beneficiaries are. Beneficiaries must be identified or specified in the trust deed. That is a requirement.
Right.
So in many cases, I found in the past that some foreign trust deed does not specify the beneficiary at the beginning, but that is treated as a corporation for Japanese tax purposes. Right. So we have to be very careful.
Yeah. Okay. Joshua, from your side, presumably a corporate structure, you could just as well do a 13R or 13X and still be okay from a Philippine standpoint. Is that correct? The 13R is obviously the one with the company.
Yes, that's correct. I think basically because the main difference between Japan and the Philippines is we are not covered by any CFC rule yet or prohibition. So I guess there's more flexibility in terms of the Philippines in setting up these vehicles. Yes.
In terms of the demand, do you see demand growing in the Philippines for international family office for the internationally spread wealth? And if so, is it more Hong Kong or is it emerging Singapore? Where do you see the trend?
Okay. In the beginning, I mentioned that the profile of the Philippine business is 80% of the businesses here in the country are family owned or controlled. So with that percentage, the probability of a demand for family office would be high. There's a high prospect for doing these kinds of family offices. And in terms of the preferred place, I would say Hong Kong and Singapore would probably share an equal pie.
Right.
But of course, it depends on the attractiveness of the vehicles that each of these jurisdictions would offer. Yeah.
Right. Right. Okay. Okay. All right. I think it's 5 o'clock now, so we're on the hour. No further questions from the sort of attendees. So I think what we'll do is we'll wind up today, and I'll just say sort of warm thank you to Joshua, Sushi, and Spencer for spending time on this webinar, and obviously to all the attendees who took time out of their schedule to watch this. As I said before, the recording as well as the slides will be made available. And just with the normal admonition that the views expressed by the lawyers here and obviously Spencer are not binding in any way. These are general views expressed on the sort of scenarios that we've been sort of going through and shouldn't be relied upon for any purpose going forward. You need specific advice if you're dealing with specific issues. So with that said, we've got a week off next week and then we're back for the sort of double header where we deal with Malaysia, Thailand, and then we wind up with the single family office. And as I said before, we'll be concentrating on looking at the governance between a VCC and using a PTE going forward, and also looking carefully at how the VCC legislation is developing and any future plans with regards to that, and then winding up with some tax planning issues that arise on transitioning a family office across generations. So from us today, thanks very much for spending time, and I think we'll just wind it up now. Thank you. Thanks, everyone.
Thank you.
Thank you, everyone.